We've looked at triggering laws. You mentioned a little bit of soft and hard. So we're still looking at categories of mediation law.
Mm-hmm.
We've looked at the triggering laws, laws that regulate the internal mediation process, what happens in the room. Let's look at the third category you mentioned, and that's the professional standards for mediators.
Yes.
Hot topic, right?
It's a very hot topic because it's not only about who gets to be a mediator or a professional mediator, but it's also about who doesn't get to be a mediator. So it's a very hot topic. And here you find a very big difference, generally speaking, between common law countries like England, the US, Canada, Australia, New Zealand, for example, and civil law countries, particularly civil law European countries. You find the main difference is that the standards or the requirements to become a mediator in much of civil law Europe in particular, those standards are much more onerous than in common law countries. Common law countries, you'll find something like maximum 40-hour course, whatever your background.
Mm-hmm.
So you can come and do a course, whatever your age and whatever your background, whether or not, for example, you have a university degree, and then there'll be 1 or 2 role plays as an assessment, and then afterwards you may need to join an organisation. And in civil law countries, it varies, but you'll find the requirements, depending on the country. In Austria, you need to be 28 years old. In some countries, I think including Russia and Spain, you need a university degree, for example. In some court jurisdictions in the US, you need to be a lawyer, right, to mediate in that court. So they're prerequisites. Yep. Although that was a US example, not a civil law example. But in civil law Europe, you'll find that the training you need to do varies anywhere between 70 and 400 hours. Right? So it can be a lot more. In Austria, for example, I think the number is something like 365 hours. If you have a law degree or a social science degree, you get some credit towards that. And then the assessment is typically more onerous as well. Then there's always the question, once you become a mediator, what do you need to do to stay a mediator?
Yes.
Are there any requirements for that? They're typically not so onerous, also because it's a fairly new profession. Mm-hmm. In some countries, you don't even need to mediate in order to stay a mediator, as long as you do some CPD requirements, like this course, for example. Mm-hmm. But in other countries, you do need to clock up a number of hours as a mediator or co-mediator in order to maintain your mediator status. And you'll find this regulated typically and more increasingly around the world in the form of institutional organizational rules, mm-hmm. And also, I guess, industry norms in the sense of the mediation industry regulating itself. In Australia, for example, you have the National Australian Mediation. Nothing legislative about it, set up by the mediation community itself, right? So nothing mandatory about it, right? But because it has the buy-in from various stakeholder groups, including courts and government and major corporations, it's the de facto standard. You'll find in Austria the opposite example. Austria was one of the first countries ever in the world, really, to legislate comprehensively about mediation back in 1993, 1994. Oh no, 2004. I was 10 years too early, 2004. But they were the first. And they legislated really a Rolls-Royce law. They dealt with quite a few process elements, which was unusual. Yep. Well, which is now unusual, but remember they were the first. They dealt with rights and obligations, and they dealt with credentialing, right? Setting credentialing standards, qualifications for mediators, all in the legislation. They didn't deal with triggering, which meant that they had all of these mediators but no mediation practice for a long while after that law was enacted. So that's one of the lessons we learned from Austria. Okay. But one of the tricky things is that once you've got a whole lot of detailed laws about mediation, about mediation credentialing in legislation, it's really hard to change it. And because we are still a developing profession, right? We need to have a type of regulation that is responsive,
yes,
and that is flexible, because we are changing and we are developing as a profession. So a lot of people learned lessons from some of the pioneer regulators, countries like Austria, for example, and have now decided not to legislate about that, at least at this point in time, but to try and set up uniform standards. Hong Kong's done the same thing, set up a uniform industry standard among all mediators. Germany currently is working on the same thing. There's a German mediation law, piece of legislation, that deliberately leaves out the credentialing aspect because they wanted that to be dealt with by the mediation community itself.
That is very interesting. I had a follow-up question, and it was a question about, does onerous also mean rigorous?
Yes. Yeah, I mean, that's a great question, and I think it's really it depends on the implementation, doesn't it? I think what you find generally is where you have more onerous training in terms of the number of hours. Typically, what you'll find is that there is more theory, equally as much practical training, if not more practical training compared to the 40-hour courses, and very often participants are required to co-mediate or do a number of real-life mediations as an observer or a co, even. And so in those cases, I think it is much more rigorous. And I actually think this approach to mediation training reflects a civil law mentality as opposed to a common law mentality. If you think about how the common law developed, I mean, it was something like this. I think in England, the King's men went on their horses to different villages and tried to sort out people's problems. And then after a while, they said, how did you sort that one out? How did you sort that one out? Maybe we should do it in sort of a way that's similar. And then the doctrine of precedent developed. So they went and did it first. And then they, based on that practice, they made some general principles. Whereas in, the way civil law developed was really that people sat down and thought about a comprehensive system first, right? And then, wrote it all out, developed it all, and then applied that to specific cases. And I think you really see some of that in the way that mediation has developed. You see a lot more general laws in sort of laws of general application in civil law Europe, and you'll see much more piecemeal development, regulatory development in common law countries.